previous lecture, we went through the Perari-Valan case. Perari-Valan was convicted in the murder case of late PM Sri Rajiv Gandhi. Okay. So in the previous lecture, prior to this one, we went through the whole case history, how the case happened and what were the punishments, what was the problem. Now we will be looking at Article 142. Okay? And this is, believe me, most important article, one of the very important articles relating to the Supreme Court. And we will be looking at the associated problems also, right? Article 142. Why in news? Okay? Perari-Valan, the news is that I took from the Hindu. Perari-Valan Rajiv Gandhi case convict released by Supreme Court citing extraordinary powers. The point to note here is extraordinary powers. Extraordinary powers granted through Article 142. Granted through Article 142. Article 142 grants extraordinary powers to Supreme Court to do very important point, complete justice. To do complete justice. Okay. This is the news. What further the court said that the court held that Tamil Nadu Council of Ministers advice on September 9, 2018 to very important pardon Perari-Valan was binding on the governor under Article 168. Under Article 168, governor's power to clemency of the Constitution. यहाँ पे बहुत interesting conflict, बहुत interesting new observation and बहुत interesting change you are going to see. And we are going to see how. I hope you saw the previous lecture also. Okay. Now, news from the past lecture. That is why I have also brought it. In the past lecture, I taught that Supreme Court slams the government claim that only President has power to pardon. Now, Article 72 grants pardoning power to President. Okay? And Article 161 grants pardoning power to Governor. In this specific case, the Supreme Court said that the court has dismissed the centre's argument that President exclusively and not Governor. The central government argument was the President exclusively and not the Governor had the power to grant pardon in a case under Section 302 IPC, Indian Penal Code Section 302 talks about the penalty, okay, for the offense of murder. Okay, okay, of Indian Penal Code, saying this contention would render Article 161 a dead letter, and create an extraordinary situation where pardons granted by the governors in murder cases for last 70 years will become null and void, invalid. Now usually what we study is कि the president has a wider pardoning powers, in the sense that president can only pardon in case of a court martial through a military court. That means any judgment that has been passed by the military court or for the court martial, for example, that can only be pardoned by president and not the governor. Okay. The second point to note is Article 72, Clause 1, Section 3 talks specifically that the president shall have the power of pardoning, okay, in case the sentence is a death sentence. Now, another important point that we need to observe is about the pardoning powers. Okay. Now, see, Article 72, Clause 1 section C, in all cases where the sentence is a sentence of death. If a person has been awarded a death sentence, the president shall have the power to grant pardons, reprieves, respite, or remission. All these terms I have explained at detail in the previous lecture. Kindly go to that. Okay. Or the of punishment or to suspend, remit, or commute the sentence of a person of any offense. Now, if we make a comparative analysis between the powers of president and governor, so it is clearly mentioned in all cases where the sentence is a sentence of death. That means president shall have the power to grant pardons in a case where the person has been awarded a death sentence. But there is no power, there is nothing, there is no exclusion of governor. There is no exclusion of governor, but Article 170, Article 72, Section 2, Clause 2 basically, nothing in subclause A of Clause 1. ठीक है? Nothing in Clause A. Okay, that's not very relevant. तो प्रेसिडेंट के पास पावर है कोर्ट मार्शल को पार्डन करने का इन ऑल केसेस वेयर द पनिशमेंट और सेंटेंस इज फॉर एन ऑफेंस अगेंस्ट एनी लॉ रिलेटिंग टू, मींस प्रेसिडेंट का पावर जो पार्डनिंग पावर है दैट इज को एक्सटेंसिव विद द एग्जीक्यूटिव पावर्स ऑफ द सेंट्रल गवर्नमेंट और द यूनियन गवर्नमेंट. सिमिलरली जो गवर्नर का पार्डनिंग पावर है दैट इज को एक्सटेंसिव with the executive powers of the governor or state executive, basically state government. मतलब स्टेट गवर्नमेंट की जो और सेंट्रल गवर्नमेंट की जो एग्जीक्यूटिव पावर्स जहां एक्सटेंड होती हैं, प्रेसिडेंट और गवर्नर की भी जो पार्डनिंग पावर्स हैं वो वहां तक लिमिटेड है. ओके, मतलब if a person has been sentenced under a state central law, so that pardon will be granted by central government. If a person has been sentenced under a state law, ठीक है? If a person has been granted sentenced under a state law, then the governor shall have the power to grant pardon, not the president. Okay, I hope you understood the basic. Now we'll try to understand the convention, the whole contradiction in the Perari-Valan case. The Perari-Valan case. ठीक है? How? As we observed that president shall have the power to grant pardon under if a person has been convicted under a central law. ठीक है? A central law. ठीक है? And governor shall have power to grant the pardon if the person is convicted under a state law. Okay. Now what happened is कि Perari-Valan was convicted by a Tada court. ठीक है? 1991, and his conviction was upheld by Supreme Court in 1998. Sorry. Okay, now this court framed a lot of charges against him. One of them, like for conspiracy and all, and one of them was under section 302 for murder. Section 302 for murder. ठीक है? Very important point to note here is कि section 302 for murder, the executive power of both central government and state government are concurrent. Okay, that means both state government and the central government has power to make laws in case of IPC violation of 302. ठीक है? अब उसके बाद प्रॉब्लम क्या हुआ कि टाडा एक्ट था, it was an act made by central government. ठीक है? And therefore central government said that the power to pardon the death sentence, okay, or anything or any sentence lies with central government, basically president, and not with governor, because the person was subjected by Tada court, the person was convicted under a central law, Tada Act. But important point to note here is he was only serving this 302 in 2014. Now we will be looking at the evolution of case in brief to understand the nuances of the case. ठीक है, July 1991 he is convicted by Tada court under the for the assassination of PM Rajiv Gandhi. In 1998 trial court convicted him and awarded death sentence, which was upheld by Supreme Court. In 1998 he was awarded death sentence. In 2001 he filed with the governor of Tamil Nadu for the relief by granting him pardon, which was denied. Then he again went to the president, and the president was sitting on his plea for clemency until 2011, okay, without passing any judgment on his plea. In 2014 he again moved Supreme Court, and Supreme Court said that by citing delays in the decision on mercy petitions, Supreme Court said that he has already served a sentence of 31 years. Oh, sorry. He has already served a sentence of 31 years, okay. He has already served a sentence of 31 years, and therefore his death sentence should be commuted to life imprisonment. Why? To avoid double jeopardy. To avoid double jeopardy. Okay. Double jeopardy means one person cannot be punished twice for one singular act of crime. One person cannot be punished twice for one singular act of crime. That means एक punishment, एक ही crime के लिए दो punishment नहीं हो सकती है, ठीक है. एक crime के specific elements के लिए अलग अलग punishment हो सकती है. For example, if you murder someone, there can be section 302, okay, but there cannot be section 302. That means IPC, that means you cannot be tried under section 302, and you cannot be granted the two sentences like death sentence, ठीक है, or plus life imprisonment. You cannot be granted both. Either you can be granted death sentence or you can be granted life sentence, because since you are convicted for one charge, you cannot be awarded two sentences. That is double jeopardy. That is double jeopardy. It is a fundamental right that one person cannot be sentenced twice for one crime. However, one important point to note here is that a person commits a murder, but he can be charged on different sections of the law, like conspiring to murder, and then he can be awarded one charge, one sentence on that charge specifically for conspiring to murder. For example, for the punishment is 10 years, so he can be awarded 10 years, okay, and he can be awarded another sentence also for murder. So for if he tries to destroy the evidence, then he can be charged another sentence. But for murder itself, he cannot be charged two sentences. That is called double jeopardy, and it is a fundamental right under the Constitution of India. So in 2014, the Chief Justice of India basically said that he has already served 31 years. Okay, now he has served 31 years. In 2014, it was like 27, 28, 24, 26, some such years. Okay. So he has already served a major part in the prison, so he cannot be sentenced to death. That will amount to double jeopardy, and that is why we are commuting his death sentence to life imprisonment. Commuting means transforming one form of punishment to other, okay, to lesser severe one. So that is how in 2014 Supreme Court of India commuted his death sentence to life imprisonment. फिर 2015-16 में again he submitted the mercy petition to governor, because now he was not on the death row, but he was facing the life imprisonment, and he now again has the right to file a plea of clemency. Then he again filed a plea of clemency, mercy petition to the governor of Tamil Nadu. Now what the governor of Tamil Nadu did, they did not make any decision on it, and later the governor of Tamil Nadu sent that to the President of India, ठीक है, for the consideration of President of India. तो यहाँ पे दो तीन important constitutional provisions हैं, like governor is bound by the aid and advice, okay, advice of Council of Ministers. तो ये जो मर्सी पिटिशंस हैं या क्लेमेंसी प्लीज हैं, they are not the discretionary power of governor or president. They are not the discretionary power of governor or president. Rather, the state government makes, whenever a plea comes for clemency or a mercy petition comes to president or governor, they send it to the government, respective government, for example state government or central government, and then the Ministry of Home Affairs in central government and Department of Home Affairs in state government make a decision about that specific person, and then that decision is conveyed back to president or governor, and then they are bound by the advice that the Council of Ministers tenders to them in the case of mercy petitions also. This is not an absolute discretion. This is not a discretionary power. They are necessarily bound by the aid and advice of the Council of Ministers while determining the mercy petitions. So instead of determining, now Tamil Nadu government in 2018 decided to release them, to release Perari Valan. They advised the governor of Tamil Nadu to make a decision to release him. Okay? But governor, instead of releasing him or signing that petition, sent that petition to the President of India for consideration. And that is where Supreme Court, basically Madras High Court at that time also, came down heavily upon the governor in that specific instance as to why would you send that clemency plea to president instead of making a decision by yourself. Okay. The Supreme Court observations, Tamil Nadu Council of Ministers of advice to pardon Perari Valan, because now he was not on death row. Now his sentence was commuted. ठीक है, तो governor's reluctance to take a call. Now Supreme Court has said that the governor's reluctance to take a call of pardoning him under Article 161 has made it necessary for the Supreme Court to exercise its special powers under Article 142 to pardon Perari Valan and release him, because governor has not been able to make a call on the clemency plea, and this violates the principle of justice. Okay, this violates the principle of justice. Okay, the last point is very important to note. The last point says that the court dismissed the center's argument that president exclusively and not governor had the power to grant pardon in a case under section 302 murder of the IPC, saying that contention would render Article 161 a dead letter. That means it is a very important observation that the governor now can also grant clemency or pardons in case of a death sentence. Usually what we study is the governor cannot grant pardon in the case of a death sentence. But this observation makes it applicable. Actually, in August of 2021 also, Supreme Court made an observation in a specific case that governor can also grant pardon in case of a death sentence if that death sentence is awarded under some state law. Okay. Now, what is Article 142? Article 142 is a very special power that has been provided to Supreme Court. The Supreme Court, the article say that the Supreme Court, in exercise of its jurisdiction, may pass such a decree or make such an order as is necessary for doing complete justice. This is the key word here is for doing complete justice. For doing complete justice in any cause or matter pending before the court. ठीक है? Or any decree so passed shall have the power of law, and shall be implemented throughout the territory of, and shall have the power of implementation throughout the territory of India. Okay. In such a manner as may be prescribed by parliament under any law. And जब तक parliament ऐसा कोई law नहीं बनाती है, for that means Supreme Court has the power. The Supreme Court has the power to make a decree. Decree means a specific order. ठीक है? In any certain case for doing complete justice. ठीक है? And that decree will have the power of law. That decree will be having the same power as the power a parliamentary law has. ठीक है? And it shall be enforceable throughout India. ठीक है? And the method in which that law can be implemented, that method can be prescribed by Supreme Court, and until and unless that method can be prescribed by Parliament, and until and unless the Parliament prescribes such a method for the implementation of the decree that the Supreme Court passes, the President may make such rules and regulations for implementation of that law. So Parliament has not prescribed any law, rather President has made some rules which make any decree passed by the Supreme Court under the application of Article 142 that shall be valid throughout the India. Okay, so Article 142 is a very important power that has been provided to Supreme Court for doing complete justice. Whenever in any case Supreme Court believes that a complete justice is not being done, it can pass a specific order despite the outcomes of the case. Despite any outcome of the case, it can pass a specific order where it believes an order is required for doing complete justice. Okay, that is Article 142. But one important problem with this article is the violation of the separation of powers. The violation of separation of powers. Separation of powers means the power has been separated between the legislature, the executive, and the judiciary. When the Supreme Court makes a decree under section 142, what it does is it usurps the power of both the executive and the legislature. That means it makes a law and it also enforces it. So it violates the principle of separation of powers. It violates the principle of separation of powers. And separation of powers is a very important principle for the functioning of a democracy, because the three organs of the state, the judiciary, the executive, and the legislature, should not get into each other's domains. Okay. The Supreme Court, in exercise of jurisdiction, passed such a decree. I hope you understood this. So it violates the basic fundamental principle of the democracy, that is separation of powers. To avoid excessive use, of course, because Article 142 is violative somehow of what? The separation of the principle of separation of powers. Therefore, to put a restriction on the scope of the application of Article 142 and to limit the frequency of its use, Supreme Court has in certain cases used this law and also restricted it. How? In PC Garg, Premchand Garg case, an order passed by Supreme Court under the exercise of 142 should be consistent with the fundamental rights. That is, such an order should not be violative of the fundamental rights. Okay, and it should be within the bounds of the statutory law. Statutory law is a law passed by Parliament or the state government. Statutory law means a law made by the statute, a law that is made that has been put into the statute book. Statute book means the book of the law. That means any law that is made by Parliament or by the state government. Okay? The state assemblies, they are the rightful bodies of making a law in India, right? So the statutory law should also not be violated while using the Article 142. That is what in Premchand Garg case, Supreme Court will make the observations about Article 142. In Union Carbide case 1991, basically Bhopal gas tragedy, the Union Carbide, this company, Union Carbide, was forced to make a payment of $470 million as a compensation to the victims of Bhopal gas tragedy. Okay, and Supreme Court made a very crucial observation that prohibitions on limitation of provisions contained in ordinary laws cannot be ipso facto act as prohibitions on limitations of. That means Supreme Court in the PC Garg case put a foundation or a boundary on the application of 142. But in Union Carbide case, Supreme Court said that the normal law that is applicable in the country will not be acting as a prohibition on the powers of Supreme Court to issue a decree under section 140, article 142. That means यहाँ पे they put a bound, यहाँ पे they expanded it. Okay. And the third important case, Supreme Court SCBA, Supreme Court Bar Association case 1998. Okay, the court ruled that again they wanted to limit and they wanted to put a limit in on the use of section 142. Okay, because the power, with great power comes great responsibility, right? So Supreme Court, the court said that its power under article 142 was supplementary in nature. Supplementary, that means it will run in supplement to the law that has been made by the legislatures. Okay, it will not override the law made by the legislature. Okay, because that will be very violative of the principle of separation of powers. Supplementary in nature and could not supplant. Okay, substantive law could not supplant. Substantive law, that means the law that already exists on a specific topic, or build a new edifice where none existed there. Means a new law cannot be created by Supreme Court using section 142. That is the point in Supreme Court Bar Association case 1998. That means any decree that is being passed by Supreme Court has to be necessarily within the bounds of the laws that have been made by the legislature of the government, or the legislature of the country or the states. The use of 142 cannot create an artificial law where a law already does not exist. That means Supreme Court is not a legislative body. It should not create an artificial law, but it should always make such decrees or such orders which run parallel or supplementary, which do not run parallel, sorry, which run supplementary to the original laws. Okay, so that is how these important cases, these are very important, you need to remember. Section article 142 is very important, and as we observed, the observation that can be made here is that the governor can also pardon death sentences and any such the governor can also pardon death sentences if that death sentence has been awarded in the pursuit of a state law. Okay, that is the major observation under the Perari-Valan case. I hope you understood this very interesting topic, and if you have any doubts on this, kindly reach me out in the comment section. I'll be more than happy to take them.